It's now 10 o'clock and the inquiry's resumed. Just in terms of housekeeping for anyone who wasn't here earlier in the week, there's no planned fire alarms. If they go off, Miss Hebden will direct us as to what to do. Does anyone here need assistance if there's a fire alarm? Thank you. I can see that the document list on the website was updated. I've sent through a list. The numbers aren't quite what I had down, what I shared with people. So I think a list was emailed out this morning. That's how I understand the documents to be, and the numbers we've previously used, which we do need to agree on in case you reference them. Has anyone got any comments on those numbers there?
Just that we agree with you, ma'am, that what's popped up on the core documents list isn't in accordance with the way in which you describe the numbering, and we are on the case.
Right. So long as that's substituted for it, I don't think Ms Hebden will be the person to know, but I don't think Councillor Hare's submitted anything as yet. I've not seen anything.
Okay.
No.
But Mark, we'll make sure it's changed to reflect your list and your numbering system.
Thank you. And then I can. Excellent. Thank you. When did that come in? It must have been. And I'll just add that I've got, for some reason, my laptop doesn't like the council's Wi-Fi now. It was happy earlier in the week. I've got to use my phone to link. Hopefully that will be fine and won't cause any disruption, but it won't let me connect via the council's Wi-Fi.
No, I've had the same problem, ma'am, but I have also found that persistence sometimes pays off, and it does seem to sink in again later in the day. But first thing in the morning, it's particularly reluctant to cooperate.
Well, hopefully we won't need it too much. So then in terms of documents, I've just been passed this plan that I think is identifying the location of the different parks, etc., within the scheme. Would you like to talk to it, Mr. Shrewsbury?
Yeah, I think what it's doing is identifying the species of windows park, obviously meadows on the parkland. Newlands Meadows, just by way of illustration, so one can have a spatial appreciation of where these things are in relation to the appeal site. The appellants are going to be producing something similar, though perhaps better than this, for the purposes of the undertaking. So this is only to aid your understanding of the position of these facilities and areas in relation to the appeal site for the moment.
I think that's quite helpful. Personally, I like to put something like that in the report to make sense.
Well,
whoever's reading,
ma'am, you're more than welcome to do so. So shall we give this a number then?
13. Then,
thank you.
Given that we've got number 12. Okay. So I'll update that. Right. Are there any other housekeeping matters at this point? No? Thank you. In that case, I think we will be hearing from the Right Honourable Suella Braverman. Miss Braverman, would you like to come to the table? Do you have a written version of what you're to say, or or otherwise email it to the council, or a written version would save me having to keep up. Thank you. We make that 14. Thank you. Whenever you're ready.
Right. Fantastic. Thank you. Keep going. For several years now, my constituents in the southern part of the constituency have been anxious and have been living in fear at the prospect of 1,200 homes being imposed on the land south of Longfield Avenue. By way of introduction, whilst of course the site itself is not within my constituency, it lies very close to the southern border and will undoubtedly have a major impact on residents in the Fareham and Waterlooville constituency. It's for that reason that I first objected to the application back in 2016 and have held a large public meeting with my parliamentary neighbour, Dame Caroline Dinenage MP, at which over 100 local people were present. On a show of hands in the room, everyone at the meeting objected to this proposal. And taking into account the additional written correspondence that I've received from local people over the years, I decided to write to the then Secretary of State requesting a call-in. I should add that in my almost 10 years of being the local MP, I have never seen such a forceful and clear expression of unanimous objection from a local community about a planning matter. It's no wonder, as the scheme represents the single largest development within the borough, apart from Wellbourne. Speaking of which, Wellbourne will mean the delivery of 6,000 new homes, the first of which are almost complete. I actually went to visit them a few months ago. And therefore it appears as misguided, disproportionate and unreasonable that so many more homes are to be built here now that the Wellbourne homes are coming on stream after many years of preparatory work. My primary position, Madam Inspector, has been and remains that this development should not go ahead. I note, however, that the council and the appellant have now agreed the principle of the development. I still maintain, for the record, my disagreement, but I accept that once the main parties agree, there is very little that I can say to change that particular position. Therefore, I am here to voice significant concerns about the impact on local healthcare and educational services. If this scheme goes ahead, much more regard should be given to these vital public services in any developer contribution if we are to avoid serious problems down the line. So turning to my primary objection to the proposal, there are three main reasons why I have objected to this development. As I said, I accept that the principle has been agreed. Firstly, however, increased urban sprawl will permanently decimate irreplaceable cherished countryside, destroying the strategic gap. The land is an important area of countryside and forms a critical strategic gap in the Solent region. This strategic gap acts as a practical, visible and physical juncture between Fareham and Stubbington. We need green spaces, especially in an area where green pastures are scarce. It is a matter of principle to prioritise the rejuvenation of plentiful brownfield sites rather than paving over the countryside and the developer's failure to secure the delivery, management and maintenance of publicly accessible open space within the development, mentioned as part of the reasons for refusal, is a powerful factor. Secondly, roads will become overcrowded at a critical area of travel between Fareham and Gosport. This development will place an unsustainable amount of pressure on our vital transport links, which notably are already congested. Despite the successful introduction of the Stubbington bypass, roads will become overcrowded at this critical area of travel. The Gosport Peninsula is not connected by mainland rail services, and this proposal seeks to add further complications to travel capacity due to its heavily car-dependent location. And lastly, Madam Inspector, in my view, and the main outstanding issue on which I wish to comment really today, is that local healthcare and educational services will be put under unsustainable pressure if this proposal goes ahead. Put simply, our already overstretched local services won't be able to cope. Dental surgeries, schools, hospitals, local healthcare and special education needs provisions are all at risk. And I don't think that sufficient consideration has been given to these issues. I agree with the Council's assessment that the proposal fails to secure the provision of a financial contribution towards off-site healthcare provision, fails to secure the delivery of early years provision, fails to secure the delivery of a primary school on site, fails to secure the provision of a financial contribution towards places for pupils with special education needs and disabilities, fails to secure the provision of a financial contribution to increase off-site secondary schools capacity, and fails to secure the delivery of an extra care facility. These cannot be ignored. Now, on healthcare, I note that the objection lodged by the NHS Hampshire and Isle of Wight Integrated Care Board. The development will create an estimated increase in population of 2,760 people, the majority of whom will register with Stubbington Medical Practice or Fareham Health Centre. Both of those centres are overwhelmed already, with many patients reporting that they cannot see a GP, cannot get through on the call system, and struggle to get access to the facilities. Local GPs also tell me that they are under-resourced to cope with existing demand and that their surgeries are at full capacity in general. They require a high number of new staff, medical and otherwise, to meet existing demand, let alone increased demand. There is a concern that the healthcare facility is not acceptable as it does not provide enough capacity. I note the ICB's concerns about the size, location, and lack of funding. The ICB are the professional experts on this subject, so we'll have much more detail on the issue. However, I've worked with the ICB on more general issues relating to the constituency and indeed the local clinical commissioning group that was previously for years. And I share the same concerns that they raise about lack of funding. The combination of increased house building in the Fareham Gosport area and the predominance of an older demographic is in this area mean that our local primary care services are overwhelmed. Detailed consideration must be given to this issue as I am inundated regularly with thousands of letters and emails from constituents about their struggles to access GP services. Regarding education provision, Hampshire, and more specifically Fareham, continues to experience significant pressure on school places. Numbers are predicted to grow further due to new housing. The majority of secondary pupils from this development will be able to attend Crofton School, but there will be a real need for a new primary school to provide the necessary capacity. As an MP, one of the biggest challenges locally is the exponential rise in children requiring special education needs. Hampshire County Council reports that there has been a 340% increase in the number of children with an EHCP since 2015, including a 41% growth since 2022 alone. Approximately 40% of those children with EHCP needs require a specialist school place. There is an urgent need to increase capacity significantly, and I'm not persuaded that this development addresses those needs adequately. To conclude, Madam Deputy Speaker, you can see where I've just come from. Madam Inspector, I come here today on behalf of my constituents and as an advocate for those who have serious worries about their quality of life if this scheme goes ahead. Whether they can get a school place for their children or grandchildren, whether they can access better GP services, how children with special education needs and disabilities will be supported. Right now, I do not think that this scheme provides the right answers to those matters. I accept that we need more homes, but these cannot be without the essential new services and appropriate funding that will ensure that everyone, newcomers and those already here, are looked after. In a few years' time, you will all be gone, but it will be the local residents who will have to live with the overstretched services and the adverse impact on their lives. And it will be me to whom they will complain. So I would rather that we avoid these problems in the first place. Thank you.
Thank you. Are you happy to answer questions?
Well, happy is not necessarily the right word because I haven't really been, but I know I am, of course.
Mr. Hill, do you have any?
Thank you, ma'am. Yes, I've just got a few questions. I view them as questions of clarification rather than cross-examinations, Braverman. So don't be unduly concerned. And I know you're familiar with the general nature of the forum. But you've made clear that you oppose the principle of the development. in relation to the developments being undertaken south of Longfield Avenue. That's been your long-standing position, and you wrote to the inspector. We've got that on the core documents link as F item 1, I think. That's your letter of the 2nd of September this year. At least it's called written deputation, but that's a summary essentially of your position that was available prior to you coming along today and helpfully elaborating your position with the document which you've just read. Looking at that letter, and as I say, ma'am, I think it's item 1 under the core documents F. Just
Yes, let me
maybe
do
you
that.
maybe you
Yes,
could be helped to
thank you very
follow
much.
that as well. As I say, it shouldn't come as any surprise. But thank you, Mr. Jupp, for helping with the link. There was just a single page,
Yeah.
but it sets out your objection, as I say, in principle to the appeal proposals. And as I think you've just agreed, you have consistently objected in similar terms. If we look at that phrasing there, important area of countryside acts as a practical, visible and physical juncture between Fareham and Stubbington. And then the next paragraph, building 1,200 homes on the land south of Longfield Avenue will place an unsustainable amount of pressure on the local area. And if we just compare that with what you say on your web page, which does require a minor Googling of your
Yes.
name, Suella Braverman. We look at infrastructure, transport and housing. I just invite those who have access to a laptop to follow me to that point.
It is on
No
my
surprise that this is all your own words, I think. So I'm just trying to understand the provenance of your current position. There is all one needs to do is to Google Suella Braverman, infrastructure, transport and housing. Yes, if you would do
If
that.
I can, I'll get it on my phone. Is that
Absolutely fine. I don't mind how you access it. It's only a couple of pages, but it just ties together the points from that letter. suellabraverman.co.uk/campaigns/infrastructure-transport-and-housing. Everyone got that? Oh, it comes up quite easily. And then there's a series of subheadings, M27, train and bus connections. Can I just check everyone's able to follow that?
Are you looking at the 2016
No.
document? You're looking at
I'm looking at your
my website.
live campaigns link.
Okay.
It also comes up if you Google Suella Braverman Fareham local plan, but it works perfectly well with infrastructure, transport and housing. Can I just check everyone's got it? Thank you. Do you have it also?
I haven't actually. So
perhaps Mr. Jupp can help if he's got it.
Yes, if someone
Yeah,
else,
absolutely right. Yeah,
that'd be great.
I can see it's there. Starts with an excellent profile picture, the hard hat, and then we go down to N27, train and bus connections, planning and housing, Wellbourne, which you've touched on already, Sovereign Crescent, Cranley Road, and then Longfield Avenue, we see is the next item. And if we look at that, there's just a few paragraphs there. You say on the 22nd of June 2022, so a couple of years ago, you wrote to the council conveying your objections. And you use those words that I picked up from the letter of September. This important area of countryside acts as a practical, visible and physical juncture between Fareham and Stubbington. And again, building 1,200 homes on the land south of Longfield Avenue will place an unsustainable amount of pressure on local area. Those are the same words, essentially, that you used in the letter of the 2nd of September. I'm not criticising that. I'm just pointing out the consistency. So that the points that you're making in your letter of September on the core documents link are the same points essentially that you were making over 2 years ago, correct?
In general terms,
yeah.
yes.
So Fareham Borough Council would have been aware of your opposition, certainly at the time of the examination of the local plan and at the time of the adoption of the local plan last year.
Yeah, I've made my objections public.
So essentially it had access to your objections, it knew your position, and yet it decided, the council decided, that in order to perform its duties to adopt a sound local plan, it had to proceed with the allocation, and that outweighed both your objection and the objections of some of the local residents.
Yes, I'm aware of the council's position.
Yeah. So your position is effectively contrary to that of the Borough Council in relation to this proposal.
In that regard.
Yeah, yeah. And Mr. Jupp, in his evidence on behalf of the council, says, you don't need to turn this up, I'll just read the paragraph 5.9 if anyone wants to. It's the council's position that the sooner site HA 55 comes forward and development commences, the better for meeting the objectives of the Fareham local plan on housing supply. So again, your position is contrary to the council's current position at this inquiry as expressed by Mr. Jupp.
According to the officers, yes, of course, you'll be aware of the decision in August of this year where committee members voted to refuse the application, notwithstanding the officer's recommendation.
Well, that's the position of the council to this inquiry, and as far as I'm aware, Mr. Jupp is there expressing himself on behalf of the council as a corporate body. He's not here as a sort of freelance. He's here as a representative of the council in its corporate capacity as local planning authority. That's right, isn't it?
Yeah, yeah.
And I think it's right, and I'm sure you'll have checked this yourself, that the appeal proposals, as shown in the application documentation, which has been evolving, of course, but now has come to rest with the materials on the core documents link, the appeal proposals accord spatially with the strategic allocation HA 55 lands south of Longfield Avenue in the local plan. They mesh.
Yes.
Good. And I don't know if Mr. Jupp's able to help again, but if we just have a quick look at that in the Fareham local plan, if you'd be so kind, Mr. Jupp, to help. I was just going to go to core documents 7 of Fareham local plan CD 7.1 is the adopted plan. I don't want any more. If you the extract, that's just as easy. Yes, if anyone's looking at it online via the link, it's printed pages 121 to 124, and it's PDF pages 135 to 138. If anyone's looking at it as a PDF on the core documents list, core document 7. So just check everyone's up to speed with that. I want to race ahead and put anyone at a disadvantage. HA 55 is the land south of Longfield Avenue allocation. It says it should be page 135 to 138 in the PDF, 121 to 124 in the printed copy. Everyone happy with that? And if we just scroll down to page 137, there we can see the master plan essentially that accompanies the allocation. And the point I'm simply making, I think you've already agreed, is that the proposals before the inspector record essentially with that layout.
Yes.
So I think Mr. Jupp's just giving you the right page. So
unfortunately, this printout doesn't have the page numbers on now. Which figure are you talking? Is this from the master plan?
yes, it should be printed page 123. And it's the figure that as Madam Inspector says, figure 4.4, policy HO 55 indicative framework plan. You have that? Good. Thank you so much. So, as I say, I don't think there's any dispute that our proposals accord with that. Of course, they've come forward very much parallel with that. So there's been an opportunity to ensure that the proposals mesh with the local plan. national government policy, both of the present government and the last government, is that proposals which accord with the development plan should be approved without delay, isn't it? That's NPPF paragraph 11C. Do you think there's any controversy about that?
I'm not familiar with
Okay.
the detail of
Well,
NPPF.
just take it from me that that is national policy. And if the inspector were to conclude that our proposals do accord with the development plan, it would follow, wouldn't it, that approval should come forward without delay.
As I said, my position has always been very cognizant of the contents of the local plan, the fact this site has already been allocated by the council in their local plan, and the council's position. I am here speaking on behalf of the hundreds and hundreds of local residents who have contacted me, and I said in my note, expressing forcefully and clearly their unanimous objection, something I've not seen in almost a decade of being the MP for the area. I'm speaking for them, and I'm raising their very serious concerns about the broader implications of the proposal.
Yes.
And I very much can read what the plan says, what the council's position has been. I have still felt on behalf of the local residents, it's been my duty and my view, actually, that this still shouldn't go ahead. But as I said at the beginning, I accept that the parties have agreed, and the areas for dispute have been narrowed somewhat today.
Thank you. There's only a couple of additional points I want to pick up with you, if you'd be so kind. Just going back to your webpage on infrastructure, transport and housing, just underneath the passage that I drew to your attention earlier, there's a subheading, Greenfield sites. And I'll just let you find that. And within that, you say, if we look at the second paragraph, and you're referring to the draft local plan, it sets out that where significant development does happen, new open spaces should be created or improvements should be made to existing open spaces. This all helps to protect and preserve the feel of Fareham as a green borough. The council expects developers to provide suitable recreational space alongside their housing proposals. This adds value to new developments and it enriches communities. If we just flick back to that inset that I was asking you to look at a moment or two ago from the local plan, which hopefully you've still got in hard copy form, figure 4.4, which shows the indicative framework plan. And as I say, that meshes with the outline master plan submitted with the application. We can see, can't we, that these proposals before the inspector do incorporate very significant green infrastructure, much of which is currently intensively farmed agricultural land. Over half the site is green infrastructure.
Yeah, no, I accept what you say about the plan. I do note that that there was a concern voiced by the Borough Council in relation to the provision of open space as part of the scheme. If that has been resolved already, then that is not an issue that I have. I can add any concern about.
Well, certainly it will come back to this, but it's my understanding that the council and the appellant are moving towards accord in relation to the planning obligations that cover open space. So
the main point really about that is that, as I've set out with my first 2 points, open space, open countryside, greenfield space, the gap is very important between this part of Fareham and Stubbington and Gosport. And it is very important to local residents, but also to the integrity and the quality of the local area that open space is protected and ideally enhanced. And if this development means the removal and the destruction of open space, then that is unacceptable. If it so turns out that agreement has been reached and there is a satisfactory position that has been found, then, again, my first preference is that this development does not go ahead. I am very much aware of the impact I can have. I cannot change agreement between the main parties. I'm simply here to reiterate the point that local residents will feel the adverse impact of a loss of open space in this area because of the development.
I understand that. There's 2 points, essentially. The strategic gap, of course, was considered very carefully by the council and by the inspector examining the local plan. And of course, the part to be developed, the part of the land south of Longfield Avenue to be developed has been removed from the strategic gap. That's one point. But the point I was specifically asking about you flows from your own webpage, the importance where development is going to happen of ensuring that new open spaces are created and improvements are made to open spaces, and that that there is suitable recreational space alongside housing proposals. That is advice that has been heeded in this case by these appellants.
Well, I mean,
because over half the site is open space and green infrastructure.
it depends on how you look at it. Ultimately, it's a loss. It's a net loss of open space. So that is, simply put, a bad thing in very simplistic terms for the local people looking at it from an open space perspective. So yes, you might have over half of your development being made up of open space, but on the whole, these people will come away with less open space than when they started. So that is why this is disappointing and unsatisfactory.
One needs to understand what's meant by open space, because of course that isn't accessible open space. This is going to be accessible open space. And the specific point I asked you about, flowing from your own document, is that where significant development does happen, that's the subclause. New open space should be created and improvements should be made, and suitable recreational space should be made alongside housing proposals. That advice has been heeded here, hasn't it?
Listen, I'm not going to, I am ultimately disappointed by this development going ahead.
Well,
it does represent a loss of open space. It does represent a loss of open countryside. That is not something that we are supporting. I accept the plan. I accept the parties having agreed. I will still have to, I'm afraid, on behalf of local residents, voice dismay at the overall impact of the scheme.
So could I ask you, when you refer to open space, are you talking about undeveloped land, open countryside, or are you talking about publicly accessible open space?
You mean on this web page? Listen, I wrote this web page many years ago, and I haven't looked at it until now, so I cannot clarify exactly what was in my head when I wrote it. But generally speaking, when I talk about open space, I'm talking about in a very general term, including all sorts of open space. So open countryside, accessible fields, playing fields, areas where people walk their dogs, where they might not even have access to because there's a visual amenity to inaccessible open spaces as well, which adds to the character of an area. So I wouldn't say that I'm just looking very narrowly at, open spaces where people have access to. No, open spaces which are also privately owned and privately accessible have an intrinsic value to our area.
And that applies to the scheme as well. That's your concern with the scheme, that there's a loss of undeveloped open countryside, undeveloped land.
Overall, yes. When you step back and look at it, yes, I accept there is going to be some new open space, but ultimately it represents a loss.
Thank you.
Thank you, ma'am. Just a couple of points to conclude. In relation to roads, the Highway Authority, Hampshire County Council, doesn't object in principle to this scheme, but is seeking contributions. I don't know whether you've followed those exchanges.
I haven't followed the highways issue in detail, okay, but I do note what the Highways Authority have said.
And in relation to the provision of healthcare and educational provision, those heads, those topics have already been the subject of quite detailed and specific evidence to this inquiry by the ICB, Hampshire County Council's education officer, and Mr. Hunter on behalf of the appellants. I don't know whether you read any of that material.
No, I haven't.
Well, thank you so much for your help. Thank you, ma'am.
Thank you, Mr. Hill. If you propose to refer to the web pages that you've taken us to, I do need a printed copy or a PDF of those pages because web pages change. Thank you. Ms. Braverman, anything further you wish to say?
No, thank you very much for allowing me the chance to speak today. And I appreciate the flexibility with fitting me in.
All right, thank you very much.
I was being saying that I was here. Is that all okay?
Yes, it's a public
Other,
inquiry.
it's public. Yeah, no kind of other.
Public inquiry.
Right, brilliant.
So moving on, we were going to look at the seal issue and any outstanding.
Yeah, just in terms of programme, ma'am, the way I'd was that
Just read it. So
we were going to have a potential opportunity to report back to you on any of the unresolved substantive matters arising from the topics addressed at the roundtables under the various topic heads. And also you mentioned yesterday that you would be in a position to very helpfully to give us some preliminary observations on the planning conditions. I know that the highways and the highways triggers have been the subject of fairly extensive discussion over the course of the last 24 hours. And although I haven't had a chance to catch up with Mrs. Baker, I know that she and Ms. Ballarat for the county have been working hard to try and help the inquiry and you. I don't know whether you're in a position to help with the planning conditions point straight away, as it were. And then perhaps we could just take a break and see whether there's white smoke on any of the matters that have been discussed. And we could perhaps come back. And there are a couple of general updates that I could provide as well in relation to the matters that we've already discussed at the inquiry. Then I was going to propose to come to deal with the SIL matter, more or less in the order which we've got on the timetable. But I'm in your hands.
you were also going to discuss whether there was a need for planning evidence in Chi.
Indeed, ma'am, and I did. I took that away, considered it last night, sent an email to my friend yesterday evening, and I took the view and continue to take the view that there isn't a need for calling formal planning evidence because of the level of agreement between the parties. Mr. Shajaravian says he doesn't feel there's a need to call that evidence. I have said, however, that I do wish to allow Mr. Jones, Mr. Jones, to signpost for you the materials upon which the SIL dispute turns. And we haven't looked at them in any detail. Indeed, we've rather pushed the SIL issue down the line. I agree with Mr. Shajaravian that the SIL issue turns on as both a matter of submissions and a matter of evidence, but we would nonetheless like to take you through the reasons why we have taken the position we have on SIL so that you understand those evidentially. But my view is, and again, I've expressed this to my learned friend overnight, that can be dealt with in an informal hearing format, and that I can take Mr. Jones through that material. He can lead you through it. And there's no need for it to be formally called as evidence. I've also notified Mr. Shajaravian that I do not require him to call Mr. Jupp as a witness, and I don't require to cross-examine Mr. Jupp. So it will be a much more informal treatment of these issues, although we do consider them to be important and worthy of your consideration and worthy of the Secretary of State's consideration.
That completely accords with my understanding, firstly. Secondly, both planning witnesses will be here, of course, to answer your questions, which is important. So we can accommodate all of that in the one session.
What I propose to do then, there's a few points on the UU that may well be dealt with already, but I just want to check. And it might be that some of what I've identified is already there. And then I'll run through the conditions.
Thank you.
And
And then if we were to break at that point, after that, it would be most helpful, then we could just take stock with the other issues.
Certainly. So I'm looking at the UU and the version that I had on dated the 17th of October. We've got the County Council's monitoring charge to monitor obligations, and I think there's also the Borough Council's monitoring charge. There's lots of blanks on the version I've got, which I assume have been picked up. Can I ask firstly what the Borough Council's monitoring charge is? What is it that the Borough Council's monitoring? Okay, if I ask the questions, if you haven't got the answer right now, you can give me an answer after we adjourn.
It would be the normal one. Or in the county council are submitting
Okay.
in regard to the actual trigger within the agreements. They have a monitoring officer who will be in charge of checking triggers and then see if it doesn't take action.
Okay, can you address that in your SIL statement that you're going to submit?
Yeah.
Yes. So that's the Borough Council's one, and the County Council, again, what's the monitoring charge in the highway section? I think there's a monitoring charge for the travel plan, but this is a separate charge of £13,000.
Yes, that's correct. It's the travel plans, obviously, which will form part of the Section 106 or the UU. Is normally there's a fee to approve the travel plan, because at the moment we have a framework travel plan in place as part of the submissions, and obviously that travel plan will need to be finalised prior to first occupations, and that then requires, if you like, a number of surveys and monitoring of the travel plan to take place. So it is Hampshire's County Council's policy to charge a monitoring fee for this work.
The overall monitoring fee for the County Council. So it's not in the schedules, it's just under the definitions at section 1. So it's towards the end of page 3, and that's, as I understand it, that's an additional charge to the travel plan charge.
Yes, I'd have to get back to you on that, but I suspect it is, as it states in the definition, for compliance monitoring of the various obligations. Yeah, that's the highway words.
Right. Okay. So the next query I had, it's on page 4, and it's the definition of occupation. And it's the occupation for the purposes permitted by the permission, other than construction personnel. Does that mean the occupation of any building or a dwelling? We've got commercial, and the school probably won't be the first one, but does it just relate to the housing, or does it only apply in particular schedules? I think what I'll do, if I raise these matters, you might want to go and think about that's the benefit of doing it and not leaving it till the end of the inquiry.
I completely agree, ma'am. I think it's most helpful.
So I'm going to assume that you've picked up various blanks within the scheme.
Yes, you are working from a draft that has been slightly superseded, but we have said we will make sure you have by the end of the day, the up-to-date version.
So the next one, it's Schedule 1, which is page 11. The affordable housing land, and it's talking about the land on which the affordable units will be located. So is that likely to be a separate area of the site? I appreciate at 40% it might be the specific areas, but very often they're mixed.
It won't all be in one place, Mabit. It will be scattered throughout the site. I think that's the intention. Phase by phase, there'll be an approval of areas for affordable housing as well as they work through the phases.
Yeah.
Pepper potted, I think, is the normal phrase.
We've got on page 12 definition of heart, and it's obviously a affordable housing body. It's not one I've come across before. What does anyone know what it actually stands for? Housing Association Registered Provider, I think is probably right. Actually, now I think about it. Right.
I think it is.
So page 19, and it's Schedule 2, the open spaces, and it's the so we've got maintenance charges for the LEAP, and it's per square metre. So is that per square metre of the actual LEAP? I'm assuming it probably is.
My understanding it is not.
Uh,
Yeah. Well,
And are the parties happy that that wording is sufficiently clear? So the one beneath it, the minimum requirement, and it's the minimum size of the open space to be calculated as 36 square metres multiplied by the number of residential unit. Is that open space taking into account the country park? Is it talking about gardens? I'm not very clear. And I'm not.
Further down here.
Right, thank you for that.
By public open space. Pursuant to the commission, which includes land being open sites the linear farm moves levy as indicatively shown on a plan. The lead and the very incidental open space, but not including the sports sub. So it's basically everything apart from sports lane.
Thank you. And then in terms of the open space maintenance contribution, is that a one-off payment? Is it for a period of time? I'm assuming it's a one-off payment.
Yeah.
Is that right?
Yes, I think that's correct. Yeah.
Thank you. On page 21, so again, it's the open space schedule, paragraph 4.1. It's talking about the on-site routes. My reading of that is that it will be a permissive route rather than a public right of way. Is that correct? Okay. Thank you.
Yes.
So the next one, it's schedule 4, paragraph 1, talking about the local centre. So I'm conscious that you've been discussing triggers. Paragraph 1.1 is not to occupy more than 400 residential units until the marketing scheme's been approved. My only thought on that is the approval of the submission of the marketing schemes in the gift of the developer. The approval isn't, and for instance, this application has taken quite a long time to determine, and just whether that is acceptable to the appellant. It may have changed.
I need to understand what the corresponding condition does.
That's what I was just looking at, is where the condition dealt with it.
I can leave it with you, and you can.
Yeah.
I'm happy. So I went through them separately. They came separately, and I appreciate it to be an answer to it, but that's my concern.
Yes, the potential for delay.
Condition J.
Sorry, condition
J
J
is to submit and approve a local centre marketing scheme.
Regardless of what the condition has, obviously the UU ties you.
Yeah.
And you could potentially be in a situation where if the council find the marketing scheme unacceptable, that you couldn't build out more than, well, you could build them out, but you couldn't occupy more than 400 dwellings. That was my thought on it, and that's got other implications.
We'll reflect on that.
I'll leave, as I say, these are just my thoughts from going through it, and you may well have responses. So the next one, it's page 24, paragraph 3.1, the nursery use building. Can somebody explain how that works to me? That there's a requirement to provide the nursery within the local centre, is that correct?
The intention is that there is land within the local centre that is marketed for the nursery purpose. I heard from Mr. Saunders yesterday that is in effect a private nursery operator.
So sorry, Mr. Jones, I'm struggling. Can you just
sorry.
And to provide the nursery within the local centre.
within the local centre. But we would need to market that land in order for the
To get a nursery provider.
in order for the operator to pursue that.
Thank you. Does that marketing scheme need to be agreed with the local planning authority, or is it is part of the overall marketing scheme, I'm assuming?
I believe it's part of the overall marketing scheme, but I'll check and clarify that.
Thank you. Next one, it's page 25, schedule 5. And I mentioned it, I think yesterday, we were talking about eligible residential units. So it's the education schedule, and why residential units in the local centre were excluded. And I think Mr. Jones, she said it was because they were flats, but you're going to look at that.
Yes, and there is an overlap clearly with criterion A. So I understand that the lawyers are striking out C to avoid that confusion.
Okay. The next one, it's page 34 and it's under the highway schedule, paragraph 2.1. And it might just be that I'm misreading it. And it might be that it's been updated subsequently, but it says in the event that the owner issues the notice pursuant to paragraph 3.1.1 to carry out highway works D3 prior to the occupation of 561 residential units. Is there something else that should be in there? Or does it relate back to something else?
Sorry, Mark, which paragraph was that?
It's paragraph 2.1 of the highway schedule. It's page 34 of my version. It just doesn't say what should happen. I think the same probably applies to the. I was going to say it applies to the next paragraph as well. It does. Right.
Because what it's saying is, in the event that the owner issues the notice pursuant to 3.1.1, and that is prior to the occupation of 300 residential units, the owner will notify the county council in writing whether it intends either to carry out the highway works D3 in accordance with paragraph 2.1 or pay the highway works. So once that notice is given.
Right.
Did it not refer to 3.1.2 as well?
Yeah, that's probably right, actually, but I think it does make sense. It might need a bit of tidying up there.
Okay.
Because I quite agree. When you first read that, it doesn't seem to.
No.
No, it's inchoate, isn't it? That way. All right.
we think actually might better if we just refer to 3.1 rather than 3.11. So
Right.
3.11 and 3.12.
Right.
Double check.
I looked at it last week and it didn't make sense, but it might be that I've missed something. So the next one I think will probably be addressed. It's about the travel plan and paragraph 4.2. In fact, I raised the question yesterday about when do you want to monitor, and I think you were going to be looking at that and adding it in. So so it was not to occupy it until you've paid the first instalment, and thereafter for a period of 4 years. I think that was addressed yesterday. So then the travel plan cash deposit, I'm sure that's defined. If I can. So there's no sum there. I'm not sure what sort of sum that we're looking at.
I believe we have provided the appellant with a sum, so it's a matter of agreeing that sum. And essentially it's calculated on the basis of how much would it take to implement the travel plan and the various measures and actions in the action plan attached to the framework travel plan. So I think a figure is being discussed, yes.
Thank you.
We have seen that figure, Ma'am, and it's caused us to question the best way of dealing with it, and whether in fact there would need to be a planning condition in order to allow the actual sum to be calculated on a phased basis. That's something that we'll need to continue to discuss.
Thank you. So in terms of BNG, is that being delivered on a phased basis? I know that probably needs to be linked back to the conditions in this case. Is it intended that each phase will deal with BNG, or is that over the whole?
It'll be at least 10% over the whole development. The BNG condition allows a scheme for the phase, and not all phases will achieve 10%. Some phases will achieve more than 10%, so that overall the development meets the policy requirement.
And it's the different types of units as well, isn't it? So so the reason 30 years following the start date, you've got a definition of end date, which includes or states that it's 30 years following the start date in respect to the relevant phase. So that's what I wanted to try and understand. But you're allowed to allocate the units across the site. The allocation of units is any excess BNG units. Okay. So
Mark, can I just, on those matters,
certainly.
what we're seeking to make clear is that these issues on BNG will also, it's not just the phases of development in terms of residential development, but includes the provision of the school and the sports hub areas, because I think Hampshire County Council mentioned in discussions with us, they've been hit with a BNG requirement on a large scheme before when they weren't aware of it. Because of the nature of the fact they put a Reg 3 application in later on rather than a reserved matters application. So I think we just want to make sure that the BNG requirements cover the development as a whole, and not just the housing sites, which the calculations do that, but we just want to make sure that those provisions are made in the UU. And I think it's It's not clear that they are at the moment.
That's where I am on the UU. If I move on to the conditions, unless there's anything else on the UU at this point.
Sorry, Mum, I've just been advised that the point Mr. Jubb has just made hasn't filtered its way through to our side in terms of the concerns about the sports hub and the school. So that, I suspect that needs some articulation and discussion.
Okay. That's fine. I mean, that is the purpose of this session. Okay. So conditions 4 and 5, as I mentioned before, they need to be, I just need clarity as to where to find the plans and make sure that I have got those plans. I think the land use parameter plan is at revision V, and I think I'm much earlier in the alphabet than that. So I don't know if the conditions have moved on since I've received this. So I've got the phasing plan. So the writing in amber is agreed or suggested or not disputed.
I'm not sure, Mark, because I asked, I don't recall having an answer because there's red and yellow or amber.
So prior to the submission of the first
Jones can
application, that seems reasonable.
Yeah.
Residential. Sorry. Residential phases and their associated character areas as defined by Appendix D of the local plan, and the indicative number of market and affordable homes in each phase. Are both parties happy with that wording? You are, Mr. Jupp. Are you happy?
I think so, but I'm making an assumption on what the amber and the red bits mean.
Yes. And
Sorry, is that okay?
we need
Yeah.
the amber, from my recollection, the amber were things that were generally agreed but hadn't quite been. There may have been some discussion around particular wording, but the principle was there. The red, certainly in this condition, is material that was put in by the local planning authority without having discussed it with us. And in order to meet the 2 o'clock deadline, there were some late additions put in, and that's why they're still to be discussed. And in answer to your question, Mum, no, there is no further version of the conditions compared to
Sorry,
this one. There's no further version of the conditions compared to this one.
Thank you. So looking at condition 6, we've got the primary school, and then what's been added is a safe route for access to the primary school during construction process. I'm assuming that's not contentious. And then the other addition is the location of the extra care facilities. And I see here actually that Oxley's Meadow, Newlands Meadow and the Linear Park as defined in the design and access statement. I wonder if we should perhaps tie that to a plan for when somebody in years to come comes back to it. Might be easier.
Mr. Sheridan referred to the appellants preparing a plan earlier, and it's specifically for that purpose, and it will identify just those areas of open space.
Right, is that the plan that's already come?
No, it isn't. It's being prepared.
Right.
Okay, sorry, that's going to be for the UU and conditions.
Yes.
Yeah, okay.
In terms of V, the extra care facilities, as long as it's understood that that could appear in several potential locations on the phasing plan, because there is no fix and unlikely to be a fix on its location.
I think the issue about the extra care is that it should be located close to the local centre. For reasons which I think are probably obvious. That's the issue.
Yes, and there are several locations close to the local centre. Yeah.
Would that not be picked up on the layout?
In due course in a layout, but not at the phasing plan stage.
Thank you. So condition 7 is the design code, and it ties it back to Appendix D of the local plan. It just struck me there was a lot of detail in here, given what's already in Appendix D, which is quite detailed in and of itself. So I suppose if I deal with the red text first, so we've got the addition of utility and meter boxes, and then we've got the approach to vehicular and cycle parking consistent with the adopted standards for residential and non-residential units. Obviously, they change over time as well, those adopted standards. But my question to you is, how much of this do we need, given what's in Appendix D, which goes down to character areas, essentially? So I shall leave that as a matter for you to think about. Then we have the conditions that I touched on earlier about the location of Oxley's Meadow, etc. Condition 13 is the play equipment. So it requires details of the play equipment specified by condition 6. But my thought on that shall include, so each reserved matters application for a phase. You've got the care homes are going to be a phase. Do they need play equipment? They might need a different type, I suppose. But and what about the local centre?
I think we need something along the lines of where relevant to the phase, or words of that type to enable that distinction to be drawn.
Yeah, I don't know if there's a specified, I mean, it's quite often that a specified number of play areas, aren't there, across the whole development, but I don't know, they're not identified, I don't think, on the master plan that I've seen. But if you could look at that. Um, 15, biodiversity net gain. There's reference to the biodiversity metric. I think we need to pin down which one. That's a site-wide assessment. Construction environmental management plan. Somebody's added in a tailpiece saying unless otherwise agreed in writing with the local planning authority. Is that necessary? Because it will sort of weakens the impact of thing. I think we could probably leave that off. Condition 23, surface water drainage. We need something, and I didn't see anything in the UU about its maintenance and management. There needs to be a scheme for maintenance and management for that. Yeah, I mean, it could end up, it could be part of the UU. So conditions 24 and 25, both tree related conditions. I don't think there's an arboricultural impact assessment as yet, but obviously being an outline application, it will probably make sense for a more detailed one. Should we submit it prior to some of the works commencing? But I would have thought the method statement would include what's contained in condition 25, that particularly given, as we discussed, I think yesterday, that the trees were on the perimeters of the site other than the Oxleads Wood, and whether that would just be part of the arboricultural method statement. It would be very unusual if it didn't include something of that nature. '26 is foul drainage. Certainly. 24, 25 or 24?
As I read it, it's requiring one to be submitted an assessment, but only prior to the works commencing. But I would have thought we'd want an impact assessment as part of the reserve matters application for that phase. It seems a bit late in the day if it's prior to work commencing, because you've already approved the siting of all the works and the position of all the works.
Asking for it to be approved prior to the commencement of work.
But it says shall be submitted to and approved in writing prior to the following works being commenced. It says submitted and approved.
Yeah, but for it to be approved, it'll have to have been submitted. But I'm quite happy if you want that as pre-commencement condition. Is that what you're suggesting?
Yes, yeah.
Can I leave you to discuss that between yourselves?
Okay, yeah.
As I say, I haven't noticed one on the other documents, but there may well be one somewhere in the ES. I don't know. So the foul drainage, that seeks details of connections to the existing sewerage network and capacity details for the related phase. Is that not a matter for the water company? Is that, sorry, do you need a moment? You've caught up. Right. Condition 26. It's asking for details of connections to the sewerage network and capacity details. I wondered whether that was something more for the water company. Okay. So condition 28, details of the roads, footpaths and cycleways. There's a list of matters that are required. And how much of that would be part of the overall reserve matters in terms of layout, landscaping, etc.? Are we duplicating what's being sought. I would have thought parking provision would, and the position of the routes would definitely come within the layout.
I think you're right, Mum, but is this condition not simply specifying the extent of information required for that reserve matters application?
Pursuant to one each reserve, you're quite right. Thank you. So then I got to 31, then I got to 32, and I really feel that I would benefit from you explaining to me. I think 32 is the sports hub. 32, 33 and 34, are they conditions that you've been looking at further in the light of the discussions and the UU?
32 clearly has a relationship with what happens to the land and whose responsibility it will be in due course to bring forward the details of the sports hub and implement it. And it may well be that that condition isn't required at all, or is required in a modified form, depending on those outcomes.
Okay.
Primary school details. I think the issue why this is coloured is because reference to regulation 3 was inserted. And at the time, I think the appellant felt they just wanted to reflect on the implications of that. But ultimately, the information that's being sought there, either as a reserve matters application or a regulation 3 application, appears, at least to me, to be appropriate information to be approved in due course. And then condition 34, there was an alternative form of wording set out initially that this amended text seeks to capture. But there's an overlap with 34 in terms of uses, and it may well be that when they're finally numbered and ordered, it makes sense to put those next to each other. The UU is obviously going to detail marketing area for the commercial uses and such like, as distinct from the residential uses. So there is an interrelationship between them. It's been put in as a condition because of the approval process.
Well, I think it arises because we're dealing with a UU rather than section 106 agreement, which the council's party to. So it does limit what we can achieve through the UU. That's my understanding. Yes, that wasn't one of the matters that we're haggling over, as it were.
But the UU is clear in terms of the overall proportion of the development. This is then a scheme for each of the phases.
I've looked at them briefly, and it seems that quite a few of them are related to self-build, custom build. I don't know if one party could talk me through, and then I can, if the other party's got a view on it. I don't know who starts.
I'm afraid Mr. Jupp will have to explain the left-hand column, and I think it totals 8 conditions for self and custom build. I'm quite happy to explain the succinct 2 conditions that we've proposed.
I may have to call down Rachel Hepton for these matters. She's been drafting this for the council. She's on her way.
I suppose it's not unusual to have a self-built custom build not to use new. We can do it on condition, but these conditions is the difference between
Yeah, I think it's something that would definitely benefit from further discussion. Sorry, I think it's something that would definitely benefit from further discussion between the parties. Because of the shortage of time, the local planning authority had provided a raft of conditions, and you'll see that they're fairly numerous. The appellant had put forward a simplified version, far fewer. We haven't had a huge amount of time to discuss them, but that's something we could prioritise and come back to you on if that would be helpful.
Okay, I mean, if it makes more sense to have some time outside the inquiry and move closer together, that's fine. And then, so that's...
Mark, just before you go on from that, there is an important point in relation to the 10% that's referred to. And I had hoped that we would have a statement of common ground in relation to this, and there is a draft with the council. But under condition X, should we say, on the right-hand side, it refers to not more than 10% of the dwellings for which approval is sought, and that's in a reserve matters phase, excluding apartments. Because it is now common ground, as I understand it, that because of the way policy HA9 operates, when you read the policy as a whole, there are qualifications to the 10% provision to exclude a particular type of development or density of development where it isn't appropriate in the context of the council's evidence for self and custom build. And that would in effect exclude apartments from the calculation. It would also exclude, on reflection, the extra care accommodation. The reason for that difference is because, again, going back to HA9, there is the possibility that as the evidence of marketing, as the phases progress, that might reveal by, say, phase 4, that there is no take-up of some or all of the 10% that have been identified in the first phases. And the policy allows at that point for a lesser proportion to be provided. So under the council's wording, we would always be obliged to provide at least 10%, whereas on our wording, it's no more than 10% and could be less to accord with the policy.
I've read in someone's evidence that the number of self-build, custom build that this would generate exceeds the number of people on the list for
Yes.
for that. So, and that's why you're suggesting that wording.
Yes. Yes.
I'm just, with that wording, do you need to deliver any? If it says not more than 10%. 0%,
Yeah.
Yes.
not more than 10%.
Yes.
My view is the wording of that part of the condition should say a minimum of 10% to be policy compliant. And then if you have an additional condition which deals with the marketing exercise and shows that you haven't been able to dispose of it all, then that could be qualified and allow as an opportunity to provide a lower figure. But it should start off as a baseline of providing the minimum required by policy. In terms of the other matters, excluding the apartments and the extra care, we are in agreement with now with the appellants.
Right.
So if it would be helpful, we could provide a completed statement of common ground for you regarding the 10% of apartments, and we just have to sign that.
No, I take that point entirely, Mum.
I think we probably need to look. I can understand the clauses in there, but are they best in here? Would they be better as a separate schedule? I don't see any reason why they perhaps couldn't be in here, and it's more specific than the council's condition. Can I leave you to discuss I think you need to refine it a little bit. And that goes for C and Z as well. So Z is, should they not have been taken up, the self-build or custom build. So and the custom build that I've come across, they're very often the house builder adapting the frontage a little bit, or sometimes it's even just the internal layout that's adapted. You know, some people want 2 bedrooms and some 3, but slightly smaller. But the general scale and appearance of the house, it is the appearance differs a bit, but the scale and that is generally quite consistent.
That would be the custom build element of it.
Yes,
That's
custom built,
self-built.
yeah, self-built
Very different, yeah.
varies hugely. You give identical parameters and so if you could look at maybe those three conditions and just see. And condition D, in fact, can I ask you to review all of the self-built, custom build conditions? The council set it out slightly differently to yourself. And condition G, seeking a design code for the self-build and custom build plots. Would that not be encompassed in, I think it was condition 5 that sought the design code? And I suppose it's more design parameters as much in between a code and parameters maybe. But if we could look at that goes down to J. My impression is there's probably not much between you in terms of what you want delivered, but it's how you secure it. So then moving on to condition I, which is AA for the appellant. So the council's condition requires details of the Class E floor space and community floor space.
The issue between us there, Ma'am, is the first sentence where this is required. In the council's case, it's requiring the submission of the first reserve matters application to include those commercial aspect details. There is the possibility that the first reserve matters application in the local centre is not in fact for those uses. It could be a residential use, could be the care home. Therefore, we've excluded the C2 or C3 use, so that in effect you would be allowed to submit a residential reserve matters application in the local centre without having to provide that commercial detail.
Does the council have a view on that?
I think we're happy to accept the alternative wording.
Thank you. So the next one is the local centre marketing scheme to be submitted and approved. Is this not duplicating what's in the UU?
The extra care marketing scheme. Are you on BB?
Sorry.
Are you on BB?
I'm on
Oh, J, sorry.
J, yeah. Just wonder, it seems like what's being sought there is probably very similar to what's sought in the UU. Leave that with you, see how you want to resolve it. Okay. Segregated.
I'll just clarify.
Just to clarify that, it's in here, J, because in Schedule 4 on the local centre, 1.1 refers to the local centre marketing scheme being approved pursuant to the conditions of the planning permission.
Right.
The UU directs you to a condition within the planning permission.
So K is about the segregated footway cycleway parallel to the northern boundary. The appellant hasn't commented on that. I'm assuming that's acceptable. Or?
We'd anticipated that being dealt with under the phasing plan.
Sorry, as part of the,
We'd anticipated that being addressed under the phasing plan.
in the
condition
phasing plan.
6, whereas K goes and slightly runs ahead of that.
This one, I'd need to check the actual wording of the conditions, but it's what is D4 and for which we've agreed some triggers. It would actually be split into 2 parts following the conversations this morning. So we probably will need to update the wording of that accordingly.
If we've got triggers in
Yes.
the UU, presumably we don't need
Correct, yes.
this
that's right.
condition.
Yeah.
Okay. Do you agree with that, Mr. Jones?
In principle, yes.
Okay.
I think I've not had the benefit of seeing what those triggers are.
No, I think this session is really just to flag up issues
Yeah.
that you can go and think
Yeah.
about and hopefully resolve.
And then ultimately the details of that route will be provided under the layout reserve matters application in due course.
So then we're moving on to conditions that I think are from the appellants. We've got BB, an extra care marketing scheme. The trigger point's not in there yet. Does the council have a comment on the marketing scheme?
If we can think about that, because we just need to look again at the latest wording in the UU as well, because there's reference to it in the UU. We need to
Yes.
see if there's
we could
conflict
try and
or it's necessary. Yeah,
if we need it, that's different.
but we'll look at it, yeah.
Yeah, and then so that sets CC sets out details of the scheme, what's required. So I think maybe look at that together as well.
But there is a theme on where the planning conditions is the vehicle for approval of a scheme, and then the unilateral ensures that scheme is implemented.
Certainly.
And that pattern should replicate through the various aspects: affordable housing, local centre, extra care. So hopefully we're aligned.
Right. So I think that's what I had based on the versions I've got. You obviously want to take that away and have further discussions. So it's taken longer than I anticipated. Should we take a break to 12, or do you want a longer break and then, but not a full lunch?
If we could have 20 minutes.
20
that
minutes.
would be helpful, I think.
Yes. Okay. Thank you. Are we ready to resume? Yes. How would you like to take this session?
Well, remember that the first thing I had on my list going from the programme was just to give you a short update on matters that have been aired at the inquiry so far in relation to the obligation, which I hope is helpful, and flag up a few points. I then want just to touch on programme and time frame in order to wrap this up in an efficient way. I haven't unfortunately had a chance just to touch on the timetabling matter with learned friend, but I'll just say what I need to say and we can pick it up during the luncheon adjournment as necessary. But as you will have gathered, the respective experts have been working away behind the scenes to try and narrow the differences further on all of the heads. Work streams are underway. I know there's a meeting going on now involving some of the education team discussing the primary school site, including engineers, etc., to try and pin down some further details in that regard. We are very anxious to book in some time with the council team on Monday morning to discuss conditions, and I know that my clients have made an approach already to try and book in a slot on Monday morning to try and finalise differences on the planning conditions, all with a view to trying to conclude matters in the early part of next week. In relation to the unilateral on highways, as foreshadowed earlier, Mrs. Baker and Ms. Ballarat have been hard at work. I understand they're 99% there in terms of agreement on the triggers. I don't know whether the friends had similar instructions, but rather than give you a verbal update, which isn't going to be of any help at all, we're going to have those matters of agreement piled in a table so that you have the respective parties' positions on those in tabular form. And indeed, that table is going to deal, we hope, with all matters of difference in relation to the inputs to the highways element of the obligation, and hopefully will be accompanied by an updated statement of common ground as well. Target Monday, fingers crossed. But in relation to all of those various triggers, we're going to be simplifying that dramatically for you, which I'm very pleased to be able to report. In relation to health, my updated instructions are that we've had further engagement with the ICB in relation to trigger points for payments on the alternative, which contemplates payment being made, and also looking at the phasing of the development and trying to blend the trigger points that the ICB referenced in their most recent email from the other day with the issue of the phasing of the scheme. Again, a draft is with the ICB and is being considered, so we hope to give you a further update on that at the beginning of next week. In relation to education, we are turning our minds very much to the formulating an obligation in a way that accords with the evidence that you heard yesterday in relation to the point at which the pupil yield sits between the 1 form of entry and the 1.5 form of entry school, how that can be managed at this period when we don't know the full details of the pupil yield, how we can avoid over providing capacity on the site, how we can capture a formula in financial terms that properly accords with SIL 122, and doesn't either over or under provide for the needs that might be generated by the development, bearing in mind the level of uncertainty that necessarily exists at this stage. So working on that, and Mr. Saunders is on the call about the site at the moment, but we're hoping to be talking to him further between now and Tuesday.
So in terms of that, are you looking for an agreement? Are you hoping to reach an agreement, or are you trying to explain your position?
I think we're trying to find a formula that would be agreed. That's the idea. There isn't a dispute, unlike the position with health. There isn't a dispute in principle in relation to the primary school. It's a question of how you find a formula which accords with SIL 122, really, and that's what we're exploring at the moment. And we've come up with some new ideas that might help move the matter forward, with the hope and expectation of agreement, yes, on that one. Sports hub, we've got these outstanding points in relation to the value of the extra 0.72. You kindly indicated your wish to have that resolved quickly, and we hope that we'll be hearing from the council in relation to that by close of play tomorrow. There is also an outstanding point that we very much hope to hear back from the council in relation to the trigger point for the sports hub, where we are not in a position to accept the 300 unit figure, and we put forward the 700 unit figure. We need to have some clarity on that, and I think that's a point for the council to come back on over the course of the next day or so. There's nothing more that I want to say, ma'am, in terms of reporting back to you where we are with these various discussions. There is progress being made. A lot of work's going on behind the scenes. I just wanted to reflect for a moment with you about timetable, and thinking that we've got at the moment one further slot on Tuesday morning to go through all of the details of the outstanding points on the planning conditions and the obligation, and that will be it. Is that going to be enough time? Do we need at least to hold in reserve the possibility we might tip into a shorter session on Wednesday morning? How does that affect people's timetables? I'm trying to be pragmatic and thinking ahead. I just wanted to mention that. I haven't unfortunately had a chance to talk to a friend about it yet, but I'm just fearing the worst, that there may be some matters that come out of the Tuesday morning session that require further work. And I know, ma'am, that you won't want to close the inquiry on Tuesday if there's any flex in the substantive provisions on either the planning obligation or the planning conditions. If it's simply a matter of execution, then I'm sure you would extend some time for that. That is commonplace. But if there's going to be if any of the parts are going to move, then I know you'd want that aired in open inquiry. And so I just raised the possibility that we might need to have at least the option available to us of coming back on Wednesday morning to tie up any loose ends.
Thank you. If we could start the council's view on the summary that Mr. Hill's given me, are you in agreement with that?
Yes, it's the first time I've heard it, but I think I agree with most of it. There is still much to be done on the unilateral undertaking. I mean, I've been through it myself very carefully this morning again, and I can still see where there needs to be quite a lot done. And I know that's being discussed. Having said that, I do think it's important that we keep Wednesday as a reserve day. And I say that because with all the best will in the world, we're now dealing with a very, very short time frame for an undertaking which has to be drafted, as it were, in the alternative all the way through. And those triggers are now changing as well. So you will be provided with alternative triggers to consider in your report to the Secretary of State. So it's important that we do get it right. And as I say, with the best will in the world, people have other commitments too. And although they're striving to do their very best, we do need to have that bit of flexibility.
Um, sorry, I'm happy to keep Wednesday in reserve. I mean, I did actually air that, I think yesterday, that there might be a benefit of resuming them, but I think if on Tuesday we could hear any outstanding matters, because I do agree, I think there's a fair amount of work in terms of where things sit, in terms of conditions relative to the UU. And I'm happy I'd like to close the inquiry. I think every time you hold it open, something happens that you'd rather hadn't. So I would hope to close the inquiry then on Tuesday or Wednesday. I'm happy to give 10 working days for execution of any documents.
20th. What does that mean in dates? Now, just on that issue of execution, we have been looking into when we can get everyone available, and I've been told it's the 20th of October, which is possibly slightly further than the date that you anticipated. Sorry, November. What have we? 20th of November. Because someone is away. What would that take us to? 5th, 6th. That would be 14 days. Rather than 10.
Sorry,
from Wednesday.
14 days from Wednesday is the 20th of October.
Right, isn't it?
Is that an issue for you? Other people that need to be party to the UU available to sign?
They are, ma'am, but I say we've been thinking ahead about as to how this would work, and having made inquiries, I think we needed to get everyone together on the first day we could get everyone together was the 20th of November, which would be 14 days from the 6th, which is next Wednesday, I believe.
So that's the 20th. Why don't we say then the 22nd of November? I do need it by then.
Yes.
Because I've got another.
I'm grateful for the indulgence that you've already shown.
But I'm assuming that it won't change from whatever we discuss on Wednesday. And
ma'am, I think no.
If it's just the execution, I can get on.
I've been doing this long enough to know that we don't change the substantive terms. We don't want to change anything in that is. And it has an operative significance in terms of the obligation from the moment you close the inquiry to the point of execution. The only thing that is changing is it takes legal effect from the moment when execution is completed. And that is only in that regard that I ask for your indulgence, and I'm grateful. The 22nd of November will work.
So I'm happy to do that. Obviously, there will be no changes to the content, but obviously the council would want to reassure itself that there's no change to the content. I'm supposing if there's any way that you can communicate it to the council. If not, I don't know if the council would be in a position to let me know very early the following week. I wouldn't expect there to be anything that you need to come back on, but if you look at it and you think something's changed, which I sincerely hope it won't, I'm just very conscious that you probably need to have sight.
If there's a drafting issue, we will let you, PINs, and the appellant's team know as soon as possible.
Right. So if you can keep in touch with each other on that.
Yes, of course.
Keep your availability around about them, because I've just with other commitments I need to.
That's understood. If it's of assistance to you also, I'm going to indicate how I'm going to deal with closing submissions.
Yes.
I say that because I'm not going to be very long at all. I don't see the point. It's not like you've been sitting through a load of cross-examination and want all the strands brought together for you. So what I'm going to do is address the alternatives available to you by reference to the draft unilateral undertaking at that stage, and make any other points of principle in submission if I need to at that point in time. So that's going to be my approach. And I'm not going to take up much inquiry time in closing.
Thank you for that. Mr. Hill?
Ma'am, so I suppose we're talking about either next Tuesday or if we need it next Wednesday, depending on how things go really on Tuesday morning. Likewise, I am not going to take a great deal of time in closing, but what I will do is simply draw together our case in relation to the alternatives that we say you should be recommending to the Secretary of State where there are alternatives available. And we know that is confined to a relatively narrow number of areas. And the only other thing that I wanted to just to check up on was you'd asked the council for a SIL compliance statement in relation to elements of the obligation where there was agreement, and that's a fairly standard request. I don't know whether there's any likely timing on that. And then we will endeavour to put together an explanatory note to go with the final version of the unilateral, just to take you through
I think that will be helpful.
Yeah.
This particular case. Okay, so we'll plan on resuming on Tuesday at 10 o'clock and then keep Wednesday available
as a result.
which would give you Tuesday to tidy up anything that
Yes.
arises. Yes, is everybody happy with that approach? Thank you. So in terms of our next session, is there anything else?
No, I think those are the loose ends that I wanted to report back on, ma'am, in relation to the progress that's being made with the unilateral. I think that only leaves for today now this small subset of the planning case that Mr. Jones speaks to in his proof and in his rebuttal. And what we wanted to do, so I hope I indicated first thing this morning, was signpost for you essentially the materials which have led us to the position set out in our evidence that the council should be deploying some of the £10 million SIL receipt it's going to get from this development on both the sports hub and some of the off-site highway mitigation measures that it has flagged up, which are of a borough-wide significance, but which we say cannot possibly be laid at the door of the appeal scheme. And Mrs. Baker's already, in relation to that last point, given some evidence as to the actual levels of impact that are or could be attributed to this scheme and the traffic generated by it. I'm not going to go over that ground again, but I want to look at it from the lens of SIL. And Mr. Jones has flagged up a lot of these points already, but as we haven't had formal testing of evidence, it seemed to us that it was important that we explain to you the basis for our position in this regard. And I'm greatly assisted by the fact that Mr. Jones was present and engaged in both the local plan examination and the SIL examination. So he can give you some a first-hand account of how those matters proceeded. So there are 3 points we like to cover. The principles that apply. I fully accept there's an overlap with legal submissions here, which I will be making in due course as part of my closing. The sports hub and the off-site highway mitigation schemes that have a borough-wide significance. In relation to documents that you may like to have to hand, we may refer to Mr. Jones's main proof and also to his short rebuttal proof, which has a section on SIL and has some appendices that are relevant as well, which hopefully you'll have within reach. There's also the local plan itself, which we were looking at this morning with Ms. Braverman, CD 7.1. The infrastructure delivery plan, the IDP, which is CD 8.7. The local planning authority's submission to Mr. Keith Holland, the examiner, CD 8.3. And lastly, the FBC annual funding statement, CD 8.5. And I'm going to invite Mr. Jones essentially to take you through these points and just relate them to the documentation that's in the core documents. And of course, he will be very happy to answer any questions that you may have.
Thank you. If you could just give me a moment to get to the document.
And I do understand you're still hotspotting off your phone, so it may be a bit creepy.
I hope, no, I'm not. I was. Let's try again. So I've got CD 8.5, which is the funding statement. When you, is it CD 8.3?
8.3, ma'am, yes, was the local planning authority's submission to response to the Mr. Holland's questions.
The infrastructure delivery plan, I believe it's in two places, but
it's certainly at 8.7. That's where under the civil rubric, and that may well be somewhere else as well. And of course, the local plan itself is 7.1.
oh, it's in with the local plan, right? No, it's not. I've seen it.
Would we talking about the IDP?
IDP is
8.7.
8.7.
And the local plan 7.1. Which you have to go to a different, slightly annoyingly, it says at the top of that CD7, but you actually have to go back to CD7.
Really there. Right, I think I've got what I need.
Thank you, Mum. Mr. Hill's referred to the three aspects that I'll cover, dealing firstly with principles, sports hub, then off-site highway mitigation. The scheme, the appeal scheme, is liable for SIL. That's not in dispute. The order of the receipt, which the council will receive over the life of the development, is in the region of £10 million. It's estimated in CD 8.6, which is the council's report to its executive of April 2024, as 9.5 million. We estimate it to be in excess of 10 million, but that is the order of what will ultimately be funded to the council. Not an insignificant sum of money. The SIL is to be used to fund infrastructure to support development in the charging authorities area. That's the specification in the regulations, and it's also set out in the planning practice guidance. The definition of infrastructure is broad. Mr. Jupp sets that out at paragraph 4.68 of his evidence by reference to the Planning Act of 2008. It's important to understand the relationship between infrastructure planning and the community infrastructure levy. And the MPPG, and I'll give you the reference to this, it's 25-010-201-90901. And I'll just read this briefly. Charging authorities should be able to show and explain how their proposed levy rate or rates will contribute towards meeting the implementation of their relevant plan and support development across their area. Charging authorities should be able to show and explain how their proposed levy will contribute to funding infrastructure. In this instance, the charging schedule, which was adopted earlier this year, was justified on the basis of the Borough Council's infrastructure delivery plan and their estimate of the funding gap. The IDP introduces SIL as a potential source of funding at paragraph 2.15.
We're turning that up.
Yeah.
Oh.
2.15 on page 6. And in terms of chronology, the infrastructure delivery plan was March 2023. This is under the heading of policy background, sources of funding. Page 6 on the paper version.
10 of 137 on the PDF.
So paragraph 2.15 at the top of the page. The levy was introduced as a tool for local authorities in England and Wales to help deliver infrastructure to support the development of their area. SIL provides a useful tool to pay for more general infrastructure, which isn't specifically linked directly to the development. It provides a consistent approach to asking developers to contribute to infrastructure, and so on. Paragraph 2.16, quite fairly, SIL is not expected to pay for the entire infrastructure required, but it is expected to contribute. Throughout the document, there are various references to SIL forming a potential funding source. We don't need to turn up the pages, but in terms of expression, page 59, leisure facilities, page 64, allotments and cemeteries, page 66, libraries, page 75, highways and transport, page 84, walking and cycling, page 113, public rights of way. Table 7, which is on page 125 of the paper version. Mr. Hill might have the
(129) of the PDF.
what's the page?
129137 on the PDF.
125 on the paper. Sorry.
Table 7.
Yes, table 7 under the heading Solutions Table, Borough-wide infrastructure and projects.
Turn your head that way to read it.
So that table, which continues over several pages, draws together the projects that are necessary to support borough-wide infrastructure. Of the many entries, only 4 reference SEL as a source of funding. They are page 126, Osborne Street car park, which is the car park associated with Fareham Live immediately outside this building, recently demolished and now laid as a surface car park. Page 128, an indoor bowls rink. I'm afraid I've no illumination on that. Page 129 are a series of leisure outdoor playing pitches. And in aggregate, they are a rugby pitch, a 3G pitch, tennis, bowling green, netball courts. And alongside those references is a reference to them being delivered through the Sports Hub allocation at HA 55. And then lastly, immediately after the reference to the Sports Hub allocation at HA 55 is Fareham Live Theatre Project, which was opened to the public at the end of September, just gone. So the infrastructure delivery plan was a key part of the council's submissions to the SIL examination that followed later that year in September 2023. And in response to an examiner's question, the council submitted CD 8.3. And it might be worth calling that up. So there's a question at the outset regarding estimate of costs of providing infrastructure, and the answer is given by reference to the borough-wide infrastructure requirements, table 7, that we've just looked at. Questions about other sources of funding, then a comparison and the estimate of the funding gap. And then below that is a sentence: the tables following provide a breakdown of infrastructure required, the likely funding source, and the resulting funding gap. And again, the source is the infrastructure delivery plan. And you will note on there, Ma'am, strategic transport highway capacity schemes in line 1. And then in line 5 over the page, leisure facilities and a reference to Longfield Sports Hub, Longfield being HA 55. And the council spoke to this table at the inquiry, at the examination. Giving those items there as an indication of the likely types of infrastructure, and in some respects, projects that SIL, and I acknowledge it says potentially identified for SIL funding, but it was a tool to persuade the inspector, the examiner, apologies, of the merits of increasing the SIL charge that it was imposing on new development. I turn now to the infrastructure funding statement at paragraph, CD 8.5. Yes. Going to take us to Annex 1 of that document in the first instance, and that's on page 10 of the PDF. Which specifies what the infrastructure funding statement should cover. Criterion A statement of the infrastructure projects or types of infrastructure which the charging authority intends will be or may be wholly or partly funded by SIL. And that is analogous with the previous regulation 123 list. When we turn to the body of the document, we see on page 4 at paragraph 10 an explanation of SIL expenditure in that particular financial year. That comprises play areas, bus shelter improvements, and Fareham Live. My calculation is Fareham Live absorbed 96% of SIL expenditure in that particular year. Fareham Live is discussed then under paragraphs 12, 13, and 14 of the preceding sections. And that essentially explains that Fareham Live has been the preeminent expenditure, that the council has in effect borrowed money and uses the SIL receipts to repay that money, and the outstanding balance was 5.65 million at that point. Over the page, it refers to the likelihood of that balance being recovered within 3 to 4 years. But we now have a statement from the leader of the council from April of this year, as that's in my evidence, that in fact those monies, so paragraph 240 of my evidence, that those monies will have been collected during this financial year.
So that's paragraph 240 of your main proof.
That's correct.
And I'm sure you'll pick this up. Fareham Live is the same as Burnham Hall. Burnham Hall.
And that is the sum total of the discussion of SIL monies, expenditure, types of infrastructure, etc. So it doesn't, in my opinion, the infrastructure funding statement doesn't, in my opinion, set out what infrastructure projects or types of infrastructure the charging authority intends its levy, its receipt, to be used for. Now that Fareham Live is complete and that the borrowing is shortly to be recouped, the council will need to turn its mind to that point. What does it now intend to fund by way of SIL? turning at this point to the local planning authority's position, it says in terms that the use of the SIL monies is a function of the executive. It is not to be determined by any individual planning application. And essentially, they're seeking to protect the discretion of the executive in due course. So that discretion is unfettered. In essence, they're inviting the decision maker to disregard SIL as a means of funding infrastructure.
Funding any infrastructure.
Funding any infrastructure. And the extent to which that plays in to the consideration of SIL 122 tests of whether a planning obligation is necessary. And we can see the practical effects of that under the two heads of strategic highway capacity measures and the sports hub. So if I deal firstly with the sports hub, there is no disagreement that the sports hub at HA 55 was intended to be a borough-wide facility to address measures identified in the council's play pitch strategy. It is common ground that the size and the makeup of the sports hub is greater than would be required simply for HA 55. And at paragraph 5.41 of my evidence, I've reproduced the extract from the statement of common ground at the time of the local plan examination in respect of that, and Mr. Jupp has a similar extract. You can also see that from Mr. Jupp's calculation that he submitted yesterday, where by reference to the playing pitch strategy, his calculation is that the area is less than 3.45 hectares. When you add the additional elements, it's barely 3.5 hectares. So some 20% less in area, but dramatically different in type of provision. What was referred to yesterday were grass pitches, and contrast that with the items that were listed from the IDP earlier. At paragraph 5.3 of my rebuttal, I have included an extract from correspondence received from the case officer. In June of this year, the issue of the playing fields and the sports hub was a live issue at that time in consideration of the application. And Ms. Hebden writes to the appellant, then applicant. Further to our meeting last week, I've discussed the sports provision in more detail with Mr. Keane. Mr. Keane is her colleague. And I can confirm that the section 106 can be worded to allow for either the land, 4.3 hectares, to be offered to the Borough Council to provide the sports hub, or for 3 hectares of land to be equipped with the sports provision required by the obligations in the SPD by the developer and subsequently managed and maintained by a private management company. This would reflect the assumption in the local plan that the extra land was to be provided in lieu of sports provision to facilitate the council's aspirations to provide a sports hub. Which goes on to explain what the alternative would be if the council didn't pursue the sports hub or secure funding for strategic facilities. The appellant's approach has been to provide land, with the SIL receipt providing the monies to the council to lay out the provision. There has been no objection to that approach. until the summer of this year. And it's instructive that when the work that was being undertaken in relation to viability of HA55 and whether it should provide a SIL contribution and to what extent that levy should be, the input to that exercise was land only. There was no sum put in for the provision of the appellant to lay out sports pitches. The council has since altered its approach, and that is the cause of the alleged conflict with HA55. It is reluctant to commit to funding the sports hub from SIL. And we saw yesterday it's requiring via a Section 106 obligation a sum of 1.5 million for the laying out of playing pitches, regardless of the SIL receipt.
Just to confirm, I mean, in that table, which you'll be familiar with, all of this material Mr. Jones has been rehearsing relates to the first column, the facility cost 1.56.
Yes. In my opinion, ma'am, there is a reasonable expectation that having sought to persuade the SIL examiner that the Longfield Avenue sports allocation, sports hub allocation, could be funded by SIL, reasonable expectation that this would be applied consistently.
So you're on to your last point.
I'm coming on to strategic highway capacity measures. B2, B3, B4, D8 and D9, their terms we're all familiar with by now. But those are mitigation measures which are derived from the forecasts of cumulative traffic at the individual junctions. The baseline at 2036, which will have included background growth to that period, development-related traffic from all of the local plans proposals. And Mrs. Baker explained the comparative queuing, which illustrates the magnitude of the effect of the appeal scheme as part of that overall traffic. And that is a small proportion, as you recall. So those mitigation measures are derived from borough-wide traffic growth. And because of that, again, there should be a reasonable expectation that having sought to persuade the SIL examiner that strategic transport capacity improvements could be funded by SIL, that this again would be applied consistently. And consistency is an important principle. In the event, ma'am, that you agree with our interpretation on this point, what then is in front of the council? It will have received the appellant's SIL contribution intended to fund the sports hub and junction improvements consistent with its position in 2023, the local authority's position at that point. And it will have to make a choice. Does it use those funds as they indicated? And in the case of the sports hub, deliver the vision or not? And they will take that decision in the context of the conclusions reached by yourself and the Secretary of State, not because of that conclusion. It will need to be an input to their decision-making process when it comes to turn its mind to the use of SIL monies. Your conclusion in respect of that point. It will remain their choice whether to spend the monies it's received in the manner that was intended. And in considering whether a planning obligation is necessary, the question must be posed of whether there is that reasonable expectation based on the contemporaneous material that SIL would be used to fund that type of infrastructure. My final point, Ma'am. In my rebuttal, there is a short table at paragraph 3.6. Page 7, which attempts to calculate what would arise in the event of our proposition. When we have a SIL receipt using the council's figure of 9.5 million, the balance of Fareham Live at 5.6 million, the cost of the laying out of the sports hub at the time that this was written, the cost of the off-site junction improvements, B2, B3, B4, D8 and D9. And then the final line is the residual funds. So the council will still have SIL receipts available to it. Just from HA 55, it will still have a residual sum, yet having also been able to fund those borough-wide strategic infrastructure projects.
Thank you, ma'am. I hope that's clear. As we've indicated, I shall be returning to some of those points in closing submissions, but we did want you to be aware of where the references are found and just have a brief journey through the documents that support the position that Mr. Jones has explained.
I think what Mr. Jones has explained is clear. The point that I want to be certain about, I understand the appellant's position in terms of the highway improvements. In terms of the sports hub and the discussions we had yesterday, the table, and are you suggesting that I should only accept those obligations if I don't? I should only accept those obligations if I don't think they should be funded by SIL, or are you saying that's a separate provision and the additional sports hub provision should be by SIL?
There will be an alternative proposition in the unilateral, which relates to the 4.3 the provision of the 4.3 hectares and Mr. Jupp's explanation and his numbers. So on the basis of the council's case, the land and a financial contribution will be provided. On the basis of our case, it would simply be the provision of land for 4.3 hectares to the council. And then the SIL money is being available to fund the laying out of it.
Council.
Yes, ma'am. Yesterday, you heard from Mr. Jupp about his new approach to the sports hub. And linking the specific provision of the sports pitches based on SPD requirements, changing room and car parking directly to the size of the proposed development. There is distinction to be drawn between what is a borough-wide facility which would likely in the future include 3G pitches and other such facilities, which go well beyond the requirements of this particular development, and which are intended in total to perform a borough-wide function. That needs to be distinguished, as it were, from what is required for the purposes of the development, even if it also performs a slightly wider function as a means of integrating the population and making and sharing of facilities amongst the wider population. And I made that point in my opening. So that's the first point. Your consideration won't be as to speculate on whether or not SIL funds either morally should be available or could be available in the future. That's not your judgment with respect. Your judgment is based upon what the development itself requires and whether therefore the contribution sought is SIL compliant. So that's the first point. The second point I make is this. It is of course open to a case officer in discussing an application to form a particular view about the application and its merits and its components. But those views don't necessarily bind the council. They certainly didn't bind the council in this case. And the council's current position is entirely justified by reference to the need the development generates. And it might well be, having made a concession to Mr. Jupp's new formulation of taking the value of the additional land off the contribution required towards the necessary elements of sports provision to meet the needs of this development. Remember that the solution is entirely fair and reasonable. So that's our response to that. I'm not going to deal with the issues of general highways, where it's the B2 to B4 elements. I'll make submissions in relation to those. And very much will depend upon the concessions being made by the County Highways Authority in relation to the triggers and the apportionment, should you go down the apportionment route. So I'll leave that for submission. Anything else? No, that's fine. Thank you very much indeed.
No, ma'am, I don't think there's anything further that we need to say. Of course, the different trails, it might well be that with the value of the land deducted, we end up with an entirely fair and reasonable outcome. Our fingers are crossed. Let's see what transpires. Yes, ma'am. We didn't quite conclude yesterday the discussion of whether you would be helped by having any of the highways witnesses there, but we rather assumed that you felt you didn't need them there. Yeah. Right, okay. Well, she's fled. Yeah. Well, we weren't seeking to force that upon you, but we weren't entirely sure as a team whether we'd allowed you to reflect on that. But if you're content that Mr. Jones and Mr. Jupp can point out everything that the highways witnesses have discussed, and I think they were both in the room for the whole of the highways exchanges, then we certainly don't ask that you have extra people to make the site inspection more cumbersome.
We've got a location to meet tomorrow. Being a bit cheeky, if I brought my case, could it go in your boot till the end of the visit? I haven't got a car with me. I just sit in somebody's car and then I can sort myself out. Thank you. Thanks. So I'll see you tomorrow and I'll see other people on Tuesday. If those documents are ready, once they are ready, obviously let me have them, the UU and conditions, but I don't want lots of different iterations of them, just the one that we'll be discussing on Tuesday. Okay, thank you, everybody. So we were told we could leave documents somewhere for over the weekend. Right, if I leave a pile just here,